All right, good afternoon, everyone. Thank you so much for joining us for the Managing Medicaid Managed Care webinar. I'm going to go through a couple of housekeeping items before we get started. This webinar is being recorded. It will be available along with a copy of the slides on our website at lrha.org. Your lines are muted to prevent background noise. Please use the Q&A box to put in any questions that you have. We'll address those throughout the webinar. After the webinar ends, a brief survey should automatically pop up in your internet browser. We do ask you to please complete that survey. It helps to make sure that we continue to improve all of our future events. And I actually want to note here, I do personally read all of the survey results. There is a box there for you to put in comments of any future topics, education, things that you might need support with. So please take advantage of that opportunity to tell me what you need and how we can support your facility. So with that, I would like to welcome the Health Law Center Sullivan Stolyer Schultz team. Michael Schultz has been representing healthcare providers exclusively since graduating from Tulane School of Law in 1998. As the managing partner of the Health Law Center Sullivan Stolyer Schultz, he's regularly counsels providers on fraud and abuse and regulatory compliance, develops and implements compliance programs, assists with licensure and payment issues, and represents many rural providers with their business and regulatory needs. We also have Heather Arrington with us. She joined the Health Law Center in 2019. She represents hospitals, post-acute, and rural providers in regulatory compliance matters involving fraud and abuse, EMTALA, HIPAA, and other regulatory matters. Heather counsels clients on various Medicare, Medicaid, and managed care payment matters, including defending and appealing RAC, ZPIC, TPE, and other provider audits. And finally, we have Brian Dupree, who joined the Health Law Center in 2002, bringing with him several years of experience in transactional, litigation, and regulatory practice. Brian works on the full range of healthcare regulatory and transactional issues and supports the firm's nationally recognized fraud and abuse practice group, handling state and federal fraud, waste, abuse, and enforcement issues in the administrative, civil, and criminal context. So thanks to all of you guys for being here today, and I'm going to hand it off to you for the presentation.
You want to go?
I'm going for it.
Sure. Well, okay. So we'll start with, we have certain learning objectives that we were asked to address. So this slideshow was developed to go over the MCO claim appeal process, the reconsideration and the appeal stage, arbitration stage, as well as the parallel appeal process that is offered by LDH called the independent review process. And then throughout, we'll have different tips for responding to the initial records requests, responding to the reconsideration findings, preparing the stuff with different tips on how to organize it and to maximize your chances. Because throughout this entire process, whenever you're appealing, you just have to imagine that the person that you're sending the records to has got a stack of other, well, I guess it's probably not on their desk, it's electronic now, but they have a stack of other claims they have to go through, and they don't spend that much time on each one of them. So the easier you make it for them to find the right information, the better. Anyway, so with that, we have the different MCOs, which we all know. There's Aetna, Better Health, AmeriHealth, Caritas Louisiana, Healthy Blue, Louisiana Healthcare Connections, and United. As we said, there's the two parallel processes. It's important to note that you don't have to wait to file the LDH independent review until you complete the MCO claim appeal dispute process. They can go simultaneously. So with that, I'm going to turn it over to Brian to talk about the MCO.
Good morning, everybody, and thanks, Danae, for having us for this presentation. So once your claim is denied or effectively denied, meaning that you haven't gotten a response within 60 days, you can begin one or both of the processes that Michael just mentioned. I'm going to talk first about the claim reconsideration and appeal process, and then Heather's going to talk to you about independent review. So on the step one of claim reconsideration, you've got 180 days from your denial date in order to submit your reconsideration claim. And in an ideal world, you would receive a response to that within 30 days of the MCO receiving your reconsideration request. They may also extend that 30 more days in the event that they have a need for additional information from you. Next slide, Denise. So some MCOs have different options, verbal, writing, or a web portal. I would rank my preference as web portal, writing, verbal. If it has a web portal, I would use it. 3 of them do. We'll talk about which ones. Just because we deal so much with paperwork, we just naturally gravitate towards having a record. And so I would recommend doing a writing, mailing it in if there is no web portal, and then verbal sort of as a last resort if you're in a time crunch and you just need to get something to them quickly. Make sure you provide a reference number, and then we can go to the next slide and we'll see which ones have which options. So for the first 3 at the top, they have an online option. You can see the link there in the contact information. Pay attention also to the mailing addresses, because as we go through this process, you'll see that the mailing address changes depending on which level you're at, and you want to make sure that you're sending it to the right place.
And it's also different for independent review as well.
Yeah.
So that's something to keep in mind.
Yeah, so having a chart of the mailing addresses for each step of the process can be helpful. So, feel free to save and refer back to these, and also check, for updates on PO boxes and things from time to time, because in the event that they do change.
And we've provided this in the slides so that you have the information. I believe everybody's going to get a copy of the slide, so you'll have it.
Yeah.
You don't need to be busy writing it down.
Right. And on the next slide, we have just more additional resource links. For the first 3, you can see how to submit the online requests, how to check to see if there's any updates. Those actually offer ways to see, the status of your claim and where it's at. So some of them have very intuitive user guides that kind of walk you through it. I was walking through myself the United Healthcare one yesterday, and it to me was very intuitive and pretty easy to use. For the other 2, you can see they have the written, or the phone call option, and the resources there are just to give you additional information on how the process works from their perspective.
All right, so echoing kind of what I had started with before, your best chance of success is to make it easy and show the reviewer where the information that's relevant to this particular claim will be in your medical record. So the first thing you need to make sure you're aware or understand is what are the actual billing requirements? What are the conditions of payment for that particular claim under review? Depending on the procedure, there might be, you might need to show evidence of a particular like a psych eval or I'm just thinking of or other treatments that were done prior to that would lead up to this treatment. Certain things may require a prior visit with an ultrasound or whatever it is. Depending on the type of claim that you submitted that gets denied, there's usually going to be specific requirements. So make sure you understand what those requirements are, because that's what's going to key the rest of the discussion. So, and then make sure the medical record is complete. There's a lot of denials. Like for instance, one of the second most common denial reason is that the medical records lack information that's required to adjudicate the claim. It's just missing information. So making sure that the medical record is complete will help you avoid one of the reasons claims get denied all the time. And so one of the things that people will run into once in a while is that the practitioner, the doctor, the nurse practitioner, the PA, whomever, didn't sign for whatever reason. One of the records, one of the entries one of the evaluations, et cetera, progress notes or whatever it is, prior to, or, in time. So you have a missing signature. It's possible to have that provider complete an attestation that explains that they reviewed the record, that they did perform the service on the date indicated, that the medical record entry is accurate. And then when they sign it, make sure that they sign it on the day that they're actually signing it. You can't backdate anything. Now, depending on how old the signature is, they can accept it or they can reject it, but they typically will accept it if it's a critical, if there's plenty of evidence in the record that the doctor was involved or the practitioner was involved, and it was just a technical denial because of the missing signature, and you fix it with the attestation, even though they don't have to accept it if it's more than, I think, 30 days, whatever, they typically do. So it's worth doing. And then make sure that the records that are submitted are relevant to the claim that's under review. So if the service, if the evaluation or whatever it was that the patient received on the date of service that's in question, if that was built upon or dependent upon a prior visit and the evaluation of a prior visit or a follow-up procedure or whatever it is. So make sure that you include those records, even though they might not be in the date range specified in the request. It goes back to understanding what the billing requirements are for that claim. So you want to make sure that you show those relevant documents, even though they technically aren't in the date range. The other thing is to make it easy for the reviewer, have each of the medical records, make sure that they're organized in the same format, the same order, so that once they're familiar with your record, they start to intuitively know where to go to find the information. And then another recommendation that we find to be extremely useful is to make a table of contents on the front page of the record. This is when you're first submitting your records. Make a table of contents that point to where the key documents are that complete the billing requirements. It just provide them a roadmap so that they don't have to search for it, and it'll make it a lot easier.
Right, so you've followed the tips and recommendations, but still don't have a favorable outcome and you would like to appeal. It needs to be done in writing. So this time the phone option is out. It has to be done in writing. You need to include documentation from your reconsideration, which if you originally did it in writing, you'll have those documents more easily accessible in addition to anything that you receive from the MCO. The thing to pay attention with on claim appeals is the differing timeline requirements by the different MCOs, which we have on an upcoming slide. But first, the next slide just has the addresses for submitting your appeal. Again, they are different from the reconsideration addresses, so keep that in mind. At this stage, only one of the 5 has an online option for an appeal, and that's Healthy Blue. So you can do theirs online. The other ones you'll have to do in writing.
And one thing too is, if you notice, all of them have PO boxes. So don't wait till the last minute, because if you're trying to FedEx it or something overnight, FedEx can't deliver to a PO box.
So next slide, you'll see the time requirements. They have different deadlines. If you can do it in 30 days, that's great, regardless of the differing deadlines, just because if you just know 30 days, then you catch them all that way. But you do have 60 for Aetna and United Healthcare, and then 90 for Louisiana Healthcare Connections. But also if you're, against a time crunch where you want to be paid, then if you can do it in 30 days, then you're just getting yourself ahead of schedule and ahead of other claims that might come in that 60-day gap that you're skipping ahead of.
Yeah, that's a good point. So recommendations on drafting the appeals. When you look at the prior recommendations for when you're first submitting your information and then for reconsideration. At this point, you're building on what you did before. If you have the complete medical record and you've identified you made sure that everything is completed, everything is organized, et cetera, et cetera. At this point, you're responding to the reasons for denial. So you're defending your claim. The appeal should be matter of fact. I'm probably dating myself with the reference to Dragnet, but like just the facts, ma'am. Be matter of fact, polite. Identify the reasons for denial that you're discussing, and then identify the portion of the medical record that disproves the finding for that particular reason. A lot of times they have more than one reason, but so you take them each in turn. It also is helpful if you bait stamp the medical records so that you can refer specifically to page numbers. And so if you are looking at the reasons for denial and then can point directly to the page in the medical record where if they say that something was missing or something, a finding wasn't within range. Often, I mean, going back to the first point, so many of the appeals are because they say that the record was incomplete when it was complete. Like the documentation is in the record, they just didn't see it. So that's, by pointing to the specific page that you can make sure that they find it. And then oftentimes, it's not uncommon for them to come up with reasons for denial that don't even apply. Physician recertification requirements within a certain deadline that don't exist in the payment rules or whatever it is. If it doesn't apply, then point to where it doesn't, point back to the record, point to the billing requirements and explain why the reason for denial is inapplicable. Yeah, that takes care of it.
So the third step in the process is arbitration. You gather everything from the first two steps and submit that in writing to different addresses. On the next slide, you'll see that we've got their addresses are listed there. For United Healthcare, you see that it goes straight to the arbitration association. For the other four, you're mailing it to them. But process is more or less the same. For example, on the provider manual for Healthy Blue, they have a specific section on arbitration and how the parties select arbitrators with experience in the healthcare field. But they also mention, except to the extent the parties have agreed in the provider agreement to use an alternative means of binding dispute resolution. So you may have to check an agreement to make sure and see what type of arbitration you are eligible for based on your agreement. So just keep that in mind. Otherwise, you'll be choosing and following the American Arbitration Association rules. Even in the instance of Healthy Blue, even though you're mailing it to them, it's going to flow similarly to how it is with United Healthcare, mailing it to the Arbitration Association directly.
In arbitration, just picture arbitration as basically a private judge. Now it's more expensive because you're not paying a judge, whereas in arbitration there's fees. But you're basically doing what you did on the appeal. You're laying out what the billing requirement is, why the claim met medical necessity, or the documentation requirements, et cetera, et cetera. You can also bring in, if for some reason there's a question about medical necessity and it's a matter of difference of opinion, you can bring in, depending on the value of the claims involved, you can bring in an expert report, somebody who can provide an independent opinion on why it was appropriate for this patient to receive that service. So it's basically, if you picture court, it's basically court just in a confidential binding manner. Nothing's reported. The results aren't getting reported anywhere. They're not public. And that's it.
Before we move on to the independent review, we did have a comment from LHCC saying that they also have an online portal now, right, Heather? Is that what the comment?
Yes.
So we'll have to update and add that website onto the slide, but that's good to know, and that's great.
That makes it easy.
Yeah, it
Very-
makes it a lot
yeah.
easier.
Definitely.
Okay, so next we're going to talk about independent review. This is a fairly new process. It started in 2018. Danae, can you please go to the next slide?
Oh, that's important.
Very important, vitally. Okay, next slide, please. So just from the outset, independent review is a fairly new process. It just started in 2018. I want you to keep in mind that before we were in the internal MCO appeal processes, reconsideration, the claim appeal, arbitration, all of that is an internal process. Now we're moving to an external process that'll be going to an impartial third party, get a fresh set of eyes. That's one of the pros of this process. But something to keep in mind is that this is it can be a fairly long process. It can take almost a year in certain circumstances. It all just kind of depends on what's going on with LDH and how quickly you and the MCO are able to get your information submitted. And it has a lot of steps and a lot of deadlines. So we can take this slow. If you have any questions, please type them in the little chat box. But so independent review is an alternative process. And like I said, it's impartial, third party. This process is administered by LDH, but LDH doesn't actually perform the review. LDH has an independent review panel, and that panel is made up of the LDH secretary, 2 MCO representatives, and two provider representatives who decide, and they choose an independent reviewer who will take a look at your claim dispute. And again, like we've already talked about, this is a totally separate process. So there will be some overlapping terms, but they are completely separate. So next slide, please. And one other thing, just to go quickly, the provider may initiate this process, the independent review process, at any time. You can choose to do it before you start your internal reconsideration appeal process, or you can do it in lieu of, or at the exact same time. And that's probably what we would recommend doing, especially if you're having some trouble maybe getting responses from the MCO or finding out more about your claim. It might be helpful to file both at the same time. So that's an option.
Especially if you keep getting the same type of claims denied.
Yeah, absolutely. So yeah, something to keep in mind. So there are several different claims that are, can you go back one more? I'm sorry. There are several different claims that are eligible for independent review. It's fairly broad. Just the first overarching thing is that they have to have come after 2018, which shouldn't be an issue for most people after January 1st, 2018. But there are claims denied, claims where the MCO has recouped the money on a previously paid claim, or if you don't receive a notice, and that's the same 60-day rule as we talked about before. A 60-day is an effective denial. Claims that if you are at the arbitration process in the internal, MCO claim appeal process, you can't use independent review. So that is something to keep in mind as well. Providers are allowed to aggregate claims, but they have to have a common question of fact or law. So an example of that would be if an NP performs a psych evaluation instead of the psychiatrist. That's a common question of whether or not it's in the nurse practitioner's scope of practice. But you can't aggregate claims just because they're all denied. They have to be somewhat common and kind of
even if the denial, even if the reasons for denial are similar on similar types of claims, the facts related to that claim are different than the related to this claim. So what they mean when you aggregate is it's usually a coverage determination rather than a fact determination. Was that patient eligible for that service, or was this service provided in the appropriate setting? Or it's something that's a more threshold question that applies to all of them at the same time.
Yeah, and the independent reviewer is going to be the one who ultimately determines whether or not the claims can be aggregated. If they decide that they can't be, then you'll just be required to submit each claim independently for independent review. All right, next slide. Okay, so independent review is a two-step process. And again, like I said earlier, we're going to have some similar terms, but remember that these are completely separate. So, I just wanted to move this. Oh, no, the map.
Right.
So the first step in this process is to submit to, oh shoot, what have I done? To request an independent review reconsideration with the MCO. So typically, each of the MCOs have their own forms to be able to do this. It's usually on their website. You can sometimes find it in the manuals, but you can also use LDH's form, which we've linked in here. You just fill out that form and submit it directly to the MCO. The time frame to do this is 180 days from one of these dates, and it's a little confusing, but there are three different options. So it's 180 days from the date on which the MCO transmits the remittance advice or other notice of claim denial, or 180 days from 60 days from the date that the claim was submitted to the MCO if you don't receive any notice or a denial in the mail. So that's essentially 240 days from when you submitted the claim. And then the last option is 180 days from the date on which the MCO recoups the money remitted for a previously paid claim. So typically, you'll submit your independent review reconsideration request, and the MCO usually acknowledges it within 5 days. I think they're required to do that. They'll let you know that they've received it, and sometimes they'll let you know what the next steps are. And then the MCO must make a decision within 45 calendar days from the date of receipt, unless you guys agree on another time frame in writing. And again, like I said before, this is totally separate. So you need to be sure that you're using LDH's form or one of the MCO's forms, and it has to say independent review reconsideration request at the top.
In terms of the 180-day deadline, it's 180 days from the adverse action taken or not taken on your claim. So if they give you a decision, 180 days. If they don't give you a decision, it's after 60 days, it's considered denied. So it's 180 days from that. Or if they recoup money, it's 180 days from that.
Next slide. So these are just the addresses and the email addresses where you should send your independent review reconsideration forms. Most of them can be done by email, which nowadays is a lot easier, but you can also mail it if you so choose. Here are all the addresses. And again, these addresses are different because they're going to different departments within the MCOs. So step 2, so you've done your reconsideration. Let's say you win. Let's say the MCO reverses their decision. They will have to pay you within 20 days for all of your unpaid claims. But if you don't win and you need to go to the next step, the next thing is to request an independent review with LDH. So this is a separate form. And again, another form that's posted on LDH's website, separate from the first one. And so the LDH must receive the independent review request within either 60 days from the date that you received your MCO denial, or if you don't receive a denial, then it's within the 45-day period. You may submit 60 days from that 45th day, so 105 days from the date that you submitted your request to the MCO. So again, the form is linked here. It's a separate form, and you can submit these forms electronically or by mail also. We've got the details about that on the next slide, but LDH recommends that you submit it electronically. I think it's kind of easier for everyone because through their form, it's pretty interactive. You're able to upload your documents directly into the form, the supporting documents, and they'll ask you for things like your claim form, your remittance advice, your claim denial, recoupment letters, things like that. But you're not going to submit your medical records yet. That'll come later in the process. The independent reviewer will directly reach out to you and ask you for your medical records. So within 10 days that LDH receives the request, they're going to notify you of the status of your review. If you don't hear anything, or if you have any questions about the process, you can reach out to this email address here. So again, LDH's preferred method is through their electronic submission form, but you can go the snail mail route if you choose. So once you submit it, LDH is going to review it to make sure that the claims are actually eligible, and that all of the steps were timely, everything was timely filed, and that all of the required documents are included. If anything's missing, they'll contact you. So try to be responsive, try to check your emails because they'll do it through email. And try to keep in mind that the faster you move, the faster this process can go. So once LDH has reviewed everything, they're going to send it to the reviewer. And within 14 days after they receive the case, they're going to contact the MCO and the provider to request any supporting documentation or information, such as the medical records. And they'll give you some, I guess, direct portal access or something to be able to do that, a HIPAA secure method. So once you've done that, once they reach out to you, you'll have 30 days to submit everything. So again, try to move quickly, as quickly as you can. Anything that's submitted after that 30-day period won't be considered. So once you've gotten everything submitted, the reviewer will have 60 days to notify you of their decision. And again, there's an email address. If you have any questions throughout the process, you're welcome to email LDH about that. They're very responsive. Okay, so cost. The fee for conducting independent review is $750, and the MCO will typically front that, and they'll pay that at any time throughout the process. Most of the time, I believe it's at the reconsideration phase, but it can come later. But ultimately, the person who's going to pay that $750 is the person against whom the independent reviewer rules. So if the reviewer renders their decision in favor of the MCO, the provider is going to be responsible for reimbursing the MCO of that $750. You'll have to do so within 10 days. If you don't, the MCO can withhold $750 from funds owed to you, and LDH can potentially bar you from using this process again. But if the independent reviewer renders in favor of the provider, the MCO is required to pay you within 20 calendar days plus 12% interest calculated back to the date that the claim was originally denied. If you don't receive payment, you should email LDH. And if the MCOs don't pay, typically LDH will pay you and they will withhold $750 worth of state-owed funds to the MCO. So appealing, let's say you don't, even after the independent review process, you don't receive a favorable result. The next step would be to appeal to the state district court, which would be the venue would be anywhere where the healthcare provider or the MCO is domiciled. And that has to be done within 60 days of the independent reviewer's final decision. So this is just a timeline, and there are a lot of numbers involved in the independent review process, and it can be kind of hard to keep up. So this is just all the information that we've already gone over, all of those timeframes. And this, again, is just for independent review for LDH's process and not for the internal MCO appeal process. So keep that in mind as you're taking a look. Again, some of these things may or may not happen. For example, the 90 days on the right-hand side, if the reviewer determines that there's a medical issue and they're going to need a medical reviewer, a medical professional to review the information, then it may take longer. It can take another 90 days, and then the reviewer will have 60 days from the 90-day period. And then again, at the bottom, we've got the 20 or 10 days. Both of those won't happen because one of you will be responsible for paying, and you each have your own time frame in which to do so.
Yeah, so when all seems to be lost, if you still haven't prevailed, there's still a chance. And so, but this isn't, I mean, I certainly wouldn't count on this as being your method. But you can escalate the matter Where if the reasons for denial just clearly don't match up with the billing requirements or the documentation submitted, or you're just not getting actual answers to, if the reasons for denial are just vague and they don't really provide you with any sort of specific information about why the claim was denied, then you can escalate the matter. And the MCOs have to report on all these matters to LDH. So it's, there is teeth to this. They don't want to get these reports, but it's not the cure-all for not being diligent with the appeal process in the front end. And so we provided each of the contact information for the escalation, including some of the senior executives' email addresses.
LDH provides them.
And you can also escalate it to LDH itself. The providers have responsibilities, they have reporting requirements, they have deadlines with which they need to process claims, and they have deadlines with which they need to respond to your appeals and everything else. If they are not doing that, if they're just not cooperating, I saw one of the questions that we received prior to the presentation was, what if you keep appealing and you just don't get any responses? You can escalate it to LDH and file a complaint against the MCO, and that does get reported to the secretary. So they can, if the MCOs aren't cooperating, they're not fulfilling their obligations under their contract with the state, then the state can fine them. And it'll also go on the record. So when the next bidding process comes up for awarding those MCO contracts, that they do look at that too. But primarily they'll intervene and either fine them or usually when LDH intervenes, things get resolved pretty quickly. I had one provider who they just kept getting claims denied, and they weren't providing any sort of a reason at all. And then they finally provided a reason. It was a lab, and they claimed that the different charges were being unbundled, the different labs were being unbundled, and they completely misapplied the actual CPT guide description of the service. And so, but they wouldn't respond to any inquiries. They wouldn't respond to. We reached out to their legal counsel, everything, and nothing would happen. So we intervened with LDH, had a phone call with LDH, I think on a Wednesday. And by Friday, we got a letter from Healthy Blue saying, our bad, we're going to process all the claims. So while we say it's a last resort, it's because don't run to LDH for every little thing. But when it matters and you go to them, they are responsive.
Yeah, and if you don't mind, I would like to jump in here and just say, if you kind of hit a wall with the MCOs, for whatever reason, you can reach out to LRHA as well, and we can help kind of do some troubleshooting on the front end of, like, maybe, you have the wrong contact person, maybe the information you have is out of date, maybe, whatever the case might be. And we can try to help you kind of navigate the MCO process on the front end before having to kind of go to this escalation result, because then this becomes a whole thing, right? And obviously we don't want to discourage people from utilizing the resources that are there if they are needed. If there's an actual problem, then we need to address it. But let us help you try to kind of figure out on the front end, do you have the wrong email address? Maybe there's a new person there and you're emailing the wrong person, something like that. So we can help you kind of figure that stuff out on the front end, and maybe kind of save you some time and some headache by kind of helping you navigate the process early on.
Yeah, and you should give the MCOs an opportunity to respond and to work with you before going straight to LDH.
Yeah.
That's important. All right, does anyone have any questions? I think we've pretty much finished our PowerPoint, so we're open for questions. Kind of goes away. And if you come up with questions after, feel free to send them to Danae, or you can, our email addresses are right there. You're welcome to email us directly at any time. It can be months from now. If you think of something, that's totally fine. We're open. And if you guys submit questions, we can also, to us directly, we can submit them to Danae and she can post them.
Yeah, and I think with that comment from LHCC, I think you guys will update the
Yes,
slide.
we're
to
gonna update
include-
before we send it to you. Yes.
Yeah, and so we'll it'll take us a day or two to get the recording and the slides to you, because we will they'll go ahead and make that update, and so we'll send you the updated version of the slides via email. So while we kind of wait to see if anybody pops any questions, I'll just thank everybody for attending today. As a reminder, you should get a pop-up of a survey. Please do take that. And then go to our website where the slides and the recording will be located. There's other educational opportunities on that page. Please look through those, take advantage of those. There's older recordings on there. All of those resources are available to you. So please feel free to make use of whatever is there that's helpful to you. And you can always reach out to us for assistance. My personal email address is on our website, lrha.org. You can find me. And we're always happy to help you guys. I'm not seeing any other questions. Any last comments from our team at the Health Law Center?
No, I mean, it's just really, I just find it helpful. I've said it a couple times, so I hope this isn't repetitive, but it's a good reminder that you just have to put your shoes in the reviewer's place, or put yourself in their shoes. I mean, so when they're getting, just constant appeals that they have to look at, or medical records that they have to look at, the easier you make it on them, the more clear that the requirements are met, where to find everything, helps an immense amount. It makes a big difference. It sounds simple, but it does. Organizing the charts, making sure you don't have any missing documentation, missing signatures, et cetera. Doing those things can make a huge difference in the outcome.
And kindness goes a long way too. So be polite in your appeal.
Yeah.
Well, thank you guys. We were happy to be here with you today. Like I said, if you guys have any questions, feel free. It was Danae. Feel free to reach out to us or to Danae. We'd be happy to work with you. And yeah, thank you guys so much.
All right. Thanks, everyone. Have a wonderful afternoon.
Thanks, you too.
Thank
Danae.
you.